as our faculties. We shall discuss two Supreme Court cases, State Tax Officer versus Rainbow Papers Limited and Vidarbha Industries Power Limited versus Axis Bank Limited. The first session will be taken by Ashish Makhija, sir, on the case State Tax Officer versus Rainbow Papers Limited. Ashish Makhija, sir, is managing attorney of AMC Law Firm, a chartered accountant, cost accountant, and an advocate. He has over 26 years of hands-on experience in commercial, corporate, and allied laws. He also holds a master's degree in law from India and USA. He is a faculty at the Institute of Directors, taking Masterclass of Directors, and was a professor at Thomas Jefferson School of Law, San Diego, USA, until December 2014. He has published several books and research papers to his credit. Sir, you may now take the session.
Okay, thank you, Anu, for such a generous introduction. Well, it only needs very small correction that it is not 26 years, it's 33 years now.
Okay,
Anyhow, yeah, that's all right. That's okay. So friends, first of all, a very good afternoon to each one of you. And I think we are meeting once again on this platform, and obviously to discuss, you see, two very important judgments which are being treated as landmark judgments. Yes, they are landmark judgments to a larger extent. And I can see Mr. Satwinder Singh also. He's you see, on the scene from the car. Probably he's traveling because he told me that he has some matter. So once he finishes up with that matter, then he will join us. And we will we'll have the benefit of his words also. So till that time he is there, so I will hold the fort and I will start with the first case. So let me start with the first case, which is Rainbow Paper. I think most of you must have read Rainbow Papers by now. Rainbow Paper has caused a greater stir amongst the IP fraternity. It has brought in an element of confusion, and it has also brought in the element of uncertainty, as in some quarters some people are saying. But let me tell you, friends, where there is a confusion, there is a creativity and there is a development. So therefore, if there is no confusion, then everyone, you see, is following a status quo. Now, in a status quo, obviously, there can't be a different thought, there can't be a progress, there can't be development. So obviously, let's not look this judgment in that manner. But yes, it's a great learning for all of us. And what the law should take its next turn, I think we need to learn from this particular judgment here. So what I'll do is I'll take up this particular case for around 35, 40, 45 minutes. And then, of course, Satwinder ji will take up the second case. And then we will have a discussion on question answer session on these things. So if you have any questions, what I suggest is you can put it on the chat box, any observations, any comments which are there. So then once we are done with the cases, then we will look into the chat box. So friends, let me share my, you see, screen with you, the presentation. And it's a very short presentation just for the benefit. Well, most of the people are calling this as a rainbow judgment. So therefore, I also took a screenshot which reflects the rainbow colors which are there. It's a very colorful judgment. It's not generally, you see, what we feel is that law has different shades of gray. But I would say that these judgments have different colorful shades which are there. So it has brought colorfulness to the IBC. So let us look at whether we call it as a last word in IBC, I don't know. Well, there is nothing last word in IBC. IBC or any law for that matter is very dynamic. So there can't be any last word. But yes, we are trying to, this is the last word as far as this movement is concerned. So as of now, this is the last word. So friends, before we go into that judgment, let's understand what are the facts of the case, because most of the judgments law turns on the facts of the case. Let's try to understand that. CIRP started on 12th September 2017. The sales tax department had attached properties of the corporate debtor on 8/10/2018. That is after the CIRP date. The claim, as mentioned in the you see judgment itself, the claim was filed by the sales tax authorities before the RP. It was to the tune of 47.36 crores, and it was filed on 28th of February 2018. In fact, at another place, it was mentioned that the claim was filed on 22/10. So there are two dates which are there. There is a statement of the ASG where he says that the claim was filed by the sales tax department before the AG, before the RP on 28th February 2018. But at one place, it is in NCLAT judgment, it has been noted that it was filed after the approval of the resolution plan by the adjudicating authority. So be that as it may, obviously that is one of the questions, but let us understand one thing, that the claim was filed in a belated manner, beyond the time limits which are mentioned in Regulation 12 also. Then Sales Tax Department wrote to RP to confirm the claim on 22/10. Now, RP sent an email saying that your entire claim has been waived off. Now, waiver word is used in the resolution plan. Well, if you file a claim, either it is an admission or a rejection. So why the RP replied by saying it has been waived off? So it gives us a feeling that this letter, this email was received after the approval of the plan. So probably RP replied that, look, in the resolution plan, your entire claim has been waived off. So probably we are presuming that. Sales tax department naturally challenged the resolution plan. And on 2018, they actually filed an application before the Ahmedabad bench. But Ahmedabad bench rejected the application as not maintainable. They said, look, we already approved the plan. We don't have powers to review, so therefore we are rejecting your application. So naturally, the appeal was filed, and appeal was filed by the Sales Tax Department before NCLAT on 8th April 2019, and NCLAT dismissed that appeal. So these are the brief facts of the entire case. Now, what were the grounds of rejection, reasons of rejection by NCLAT? There are three main grounds which are there, which have been dealt in this judgment also. Number one, that Sales Tax Department approached RP at a belated stage. And here they are writing after approval of the resolution plan. So therefore, they are saying that the claim was not filed within time. So it is a belated claim. That's one. Two, they have held by looking at even the GVAT Act, because here Section 48 of the GVAT Act is involved, right? Gujarat Value Added Tax Act, Section 48. And they have also concluded by saying that Sales Tax Department is not a secured creditor. So this is their second finding which was there. And third, they have also said that Section 48 of GVAT Act cannot override Section 53 of IBC. Right? Because Section 53 also starts with non-obstant clause. Section 48 also starts with non-obstant clause. But we have another provision that if there is a conflict between, if there is an inconsistency between the two laws, then IBC shall prevail as per Section 238. So probably on that basis, they came to this particular conclusion. Now, what the relevant factors. So these are few things which we must note. And I'm also surprised sometimes that in the entire judgment, if you read the judgment, we can read the judge has recorded the arguments of SG and ASG. They argued for the Sales Tax Department, Gujarat. But if you look at the entire judgment, I could not find who argued against them, whether there was any party against them, because no arguments in opposition are recorded in the judgment. I could not find even a single argument. I mean, naturally, you see, normally in any judgment, we find that arguments for or against are there. So here the arguments are for, but nothing is against. So I'm really surprised whether any lawyer appeared and who represented, what were the arguments, nothing is mentioned in the judgment. So this is one thing I think we must bear that in mind. Now let us look at the ratio of the judgment. What the judge has concluded, whether that issue was there or not, the judge has concluded like this. If you look at para 23 and also 39 and 40, the feeling, the flair or the language which is used is that the timelines in IBC are directory in nature. Now, friends, let us understand what was the issue before this particular bench of Honorable Supreme Court. And before I deal with the ratio of the judgment or the analysis of the ratio of judgment, friends, let us be very clear. Let me place on record that we are not in the process of criticizing the judge or criticizing the Supreme Court. We are simply analyzing for academic purposes, and we are making a fair comment. This is that we are not criticizing any judge. Let me make it very clear on behalf of ICSI Insolvency and on behalf of both the faculties, I can say that. Now, timelines in IBC are directory. Now, why the why the Supreme Court concluded this. What was the issue before them? The issue before them was whether the timelines in Regulation 12, which deal with the filing of the claim within a particular time. We know that it should be filed within 14 days of the public announcement. If it is not filed, then it can be filed within 90 days. That's the maximum time limit. Beyond that, if somebody comes, RP says, sorry, I will not be able to accept it. Then the person approaches the NCLT for condemnation of delay. And if they get the condemnation of delay, only then RP is considered. But time and again, the timelines in Regulation 12 have been held to be directory in nature. Even there are NCLT judgments are there to that effect, and NCLAT judgments also there, which means that they will be liberal in granting the condemnation of delay. But here, the issue was only relating to belated filing of claims. Now, the judge, unfortunately, has gone and said timelines in IBC are directory, which means all the timelines in the IBC, not only in regulations, but even in IBC, have become directory by just this one stroke of pen, one sentence. So this is going to cause a lot of confusion because people are going to take advantage of it. But according to me, this was not the intent. If we read in the context, the intention was a little different. Number two, the Honorable Supreme Court has concluded that sales tax department was not required to file the claim. Now let us understand this. This is very important because this has caused huge confusion amongst the IPs, RPs, that look, whether any statutory authority, including sales tax or income tax or excise department or whatever department is there, whether they are supposed to file a claim. First of all, let us understand the context under which this judgment has come in, friends. Only then I'll be able to explain it. This judgment is on the unamended Regulation 12. My friends are aware that when the Regulation 12 was introduced, then the language of the Regulation 12 was different. In fact, they have not changed the heading, but they have changed the Regulation number 12.1 and 12.2. It was mentioned that the creditor has to file proof of claim. This proof of claim, these three words were replaced with claim with proof. So please understand, friends, this is very important. Earlier, the words were the proof of claim to be filed. So there was a doubt. In fact, when I read it in 2016, I was also confused whether I have to file a claim or whether I have to file only a proof of claim. But the overall intent, if we look at Regulation 7, 8, 9, 10, 11, 11A, and 12, well, the conclusion was that yes, everyone is supposed to file the claim. Because this has to be read in consonance with the public announcement. Public announcement section 15. What does section 15 says? A public announcement must be given whereby inviting the claims from the, so invitation of the claims means somebody has to file a claim. And the procedural part was given in the regulations that look, you have to use this form. But unfortunately in the regulations, the word used was proof of claim instead of claim with proof. But probably the IBBI noticed this because we also had a lot of seminars at that time. So from 3rd July 2018, now this proof of claim was replaced with claim with proof. Now this case deals with unamended regulation because the claim was filed prior to the amendment. So therefore the judge has read the unamended portion and she concludes, and sorry, not she, the judges conclude that look, the claim was not required to be filed because the regulation simply said that you have to file only proof of claim, and proof of claim will have to be filed only when asked for. If RP has a doubt, then he will ask for a proof of claim. So therefore he never asked for it. So therefore there was no requirement to file the claim. So it is coming from that background. Now today we have to apply the amended regulations which says claim with proof is to be filed. So therefore, to say that statutory authorities or including sales tax department are not required to file the claim is absolutely wrong. This has been only on the background of unamended regulation 12.1 and 12.2. So this I wanted to be very, very clear about it. So judges concluded, of course, I would say with due respects to the judges that even that conclusion is not correct because only regulation 12 is not to be looked into isolation. They would have looked into section 15 and read with all these regulations. Section 15 clearly says that advertisement, the public announcement will invite claims. So invitation of claim and filing of the claim is a must. So that was the intention which was there. Third, they have said RP because they said, look, sales tax department was not required to file the claim. And RP was required to consider the claim as per the books of account of the corporate debtor, and they should have been mentioned that in the information memorandum. Well, here two things arise. Forget about whether the claim was required to be filed or not. That's a separate issue. Assuming any creditor, assuming any home buyer, assuming any statutory authority does not file a claim. But some creditors' names are written in the books of account, which are in possession, assuming they are in possession of the RP. Now, what is the duty of the RP? Should he disclose them in the information memorandum or not? I think he has to disclose it. It should have been done otherwise also. You don't require a specific guideline or regulation for that. See, what is the purpose of information memorandum? As the name suggests, it is an information. So it is a memo of information. So every information which is in possession of the RP or the IRP, well, it has to be mentioned in the information memorandum so that the resolution applicants who are filing the resolution plan, they must know what is happening in the company. Don't you think so? Because the information memorandum contains every information under the sun about the company. So be that as it may, we will deal with it later. But here, the judge has remarked that RP failed to include the claim amount as per books of account in the information. Well, because they arrived at a conclusion that claim was not required to be filed. RP also failed. So therefore, their claim was not considered in the plan. Therefore, plan is bad. So this is the whole logic which is coming in this particular judgment. Let's move forward now. Now, if I analyze, because now you see every ratio, I think I've analyzed in my next slide. Now I can say this, and please follow this. RPs must include the information of the amount owed to the creditors as per the books of account or as per any information on data which is available with them in the information memorandum. And please read KV Developer's judgment of NCLAT and other judgments also. What the judges are saying. The NCLAT has observed in many cases that, look, as far as home buyers are concerned, supposing there were 200 allottees, you ask for the filing of the claim, only 100 allottees file and 100 don't. Now, the plan comes on the basis of, because the person who is filing the plan, he believes that there is an unsold inventory of 100 now because 100 claims have not come. Now, he also submits a plan on that basis. There is no quarrel on that. But then some allottees came to know later on, and many applications come. Some people say that I am of old age, I was under medical treatment, I am staying abroad, and so many other causes are given. Now, if such person comes back and he has almost paid 90% or 100% of the amount which is to be paid to the builder, now do you think that he should not be allowed given a flat? So, I mean, these are something where the balance is to be maintained in the society. So even NCLAT has remarked that, look, we understand that there is Ghanshyam Mishra judgment, which clearly says that it will be on a clean slate. Any claim filed after the approval of the plan will not be considered. We are aware of all those judgments. He said, but this is totally unfair. So this can be considered. And in fact, in one of the judgments, they have said that IBBI should also look into this and kindly modify your act or rules just to cover up these kind of cases also. So all I'm saying is, as far as RPs are concerned, what is my duty? My duty is that, look, in the books of accounts, if there are 100 creditors, but only 50 have filed the claim, 50 have not filed, but for those 50 also, I will mention them in the information. That's all. I'll just give the information that as per my books of account, this is the total liability. Claims have been received only by these and not by the others. Please do that. I think nobody can raise fingers on the RPs on the basis of this. Then the court has also come to a conclusion that sales tax department is a secured creditor. Now, this is a very serious thing, and let us understand. And I can say that, look, to this extent, the judges are right. Why? Let me explain this. First of all, let us look at Section 3, subsection 30 of IBC and 331. Section 330 talks about, gives us the definition of a secured creditor. And 331 deals with the security interest, because secured creditor definition actually refers to security interest. So what I've done is I have reproduced it on the screen itself. So in my slide, you can see secured creditor means a creditor in favor of whom security interest is created. So this is a simple definition, but we have to understand the meaning of the security interest. Security interest definition, friends, which is given in clause 31, is a long definition. It says it means right, title, interest, or claim to a property created in favor of or provided for a secured creditor by a transaction which secures payment or performance of an obligation and includes. Now, this is very important. First, it was a meaning definition. Second, it says includes. It includes mortgage, charge, hypothecation, assignment, encumbrance on any other agreement or arrangement, securing payment or performance of any obligation. So please look at the word charge. I have highlighted that word. I have put that in bold, charge. Now let us look at how the judges came to a conclusion that sales tax department is a secured creditor. But before I deal with that, this is also very important for me to show you. I think all of us understand that under section 77, subsection 3 of Companies Act 2013. Now there is a special provision. What does it say? It says, which starts with a non-obstant clause, it says, notwithstanding anything contained in any other law for the time being in force, no charge created by a company shall be taken into account by the liquidator appointed under this act or under IBC, as the case may be, or any other creditor, unless it is duly registered under section 77(1) of the Companies Act, and a certificate is given under 77(2). So section 77 deals with registration of charges. It says every charge must be registered, and once it is registered, registrar will issue a certificate of registration. So it says if a charge is not registered and a certificate is not given by the registrar, then such charge shall not be taken into account by the liquidator. Which means, in clear terms, if I read it, the meaning is that the creditor will not be treated as a secured creditor under the Companies Act. This is what the meaning of this particular section. And it also says, because it was modified. Earlier, it was saying liquidator appointed under this act, but this subsection was modified to add the words or the IBC, as the case may be. So a liquidator who is appointed under IBC is also covered by section 77. So means a liquidator has to ignore if the charge is not registered. Now the question because why I brought it, let's understand, let's go further. I think then we will understand. So the judge said that, look, sales tax department is a secured creditor. Why it said that? Because it based its judgment on section 48 of the GVAT Act. So I'll show you in a little while, but let's understand this. Claim filed by the sales tax department is not belated, as the period in regulation 12 is directory and not mandatory. To this extent, I agree. There is no quarrel on this. And then they say rejection of claim of the state is unsustainable in law. So merely on ground of the belatedness, they say that if you reject the ground, adjudicating authority rejects the claim or the appellate authority, then it is bad in law. So that is what they say, that adjudicating authority and appellate authority rejecting or saying that the claim is belated. I showed you the grounds on which NCLAT dismissed their appeal. First ground was belated claim. So judge says if the claim is belated, it is a directory provision, so you can't do that. And and let us try to understand the analysis. I've already explained. The court actually relied upon unamended regulation 12, and hence they said it is not applicable after the amendment. So regulation 12, which is directory, even today it is directory, no doubt about it. But they were actually relying upon the words proof of claim or claim with proof. So that was the reason, which I've already explained. Now, there is one more ratio, that adjudicating authority was required to examine compliance of section 32, and emphasis has been laid on the word satisfied, which is present in section 31(1). Well, definitely there is no quarrel to this. All adjudicating authorities are required to examine the compliance of entire section 32, including 32B. And of course, they have to be satisfied. So the meaning of the word satisfied has been expounded in this judgment in para 41 and 43. Now, these are the issues which are also coming. No plan can be accepted if it fails to comply with section 32. Well, I think there have been a number of judgments which clearly say that if 32 is not complied with, then judicial wisdom can come in. Otherwise, commercial wisdom will prevail. So only thing which the adjudicating authority is supposed to check is the compliance to section 30, subsection 2. So I don't think there is any...
Sorry to interrupt you. There is a continuous break in the your voice. I cannot hear you continuously.
Okay. Are my friends able to hear me, or is it...
Sir, you are very much
Yes,
clear,
sir.
sir.
You are
I
very
think
much clear, sir.
your voice
Yes,
is very
you are
much
clear.
clear.
Your
sir.
voice is clear.
Audio, video is very much clear.
Okay.
Very audible. It is audible.
Got it. Sandhya ji, what I request is maybe you check your...
Okay, sir. Noted. Sorry to disturb you.
No, not at all. All right. So, so plan which is not meeting the requirements is... Now, this is something which they have stated. See, look, in the facts of the case, when you start generalizing the things, then here comes the problem. Because some people are going to use this para 48. What does the judgment say now? Plan not meeting the requirement of 32 is invalid and cannot be binding on the central government, state government, or any statutory or other authority, any financial creditor or other creditor to whom the debt is owed under any law. Now, this has become very general statement. They should have restricted to say that, look, since you did not consider the sales tax claim, therefore you did not see the compliance of 32, therefore this plan is bad in law. But if you make a general statement, which clearly when you start including central government, you state government, statutory authority, or other authority, then you even extend to this any other financial creditor or other creditor. So even now operational creditors are coming here. So that means they say that if an operational creditor's dues are there as per the books of account, claim not filed, you do not consider as per section 32B, then the plan will become invalid. Now, this is, according to me, was not required, friends, and this is a very, very generic statement. I think that is why people are talking that, look, this judgment needs to be reviewed. A judgment, as we all know, always turns on the facts of each case. Now, you can't start generalizing the thing. So para 48, but unfortunately, probably will be misused by some people, operational creditors also. So they will try to create more confusion than what it is there. Now, look at this sentence. Such a resolution plan would not bind the state when there are outstanding statutory dues, para 48. I'll explain you why this ratio is coming. Then insofar as section 31(1) is concerned, there have been a number of judgments which clearly say 32 compliance is to be seen. There is no quarrel to that. And this, I would say that previous two sentences in para 48 also will apply to a particular facts of the case. So it cannot be applied to all situations. It should be applied where the facts are quite similar to what it is there in the judgment itself. Now, then the judge has even gone into presence of two words, shall and may. Shall appears in 31(1), may has been used in 31(2). The judges say may means discretion, but that discretion cannot be arbitrary, and may can also be construed as shall. So these are the three paragraphs in which shall and may things have been there. Well, friends, under certain circumstances, may can be construed as shall can be construed as may. I think all of us are aware of this. But in this particular case, whether may should be read as shall or shall should be read as may, I think the judges have not clarified it. That's the confusion. Now, I don't want to jump on Vidarbha's judgment. In Vidarbha, again, shall and may were there in section 7(5)(a) and 9(5)(a). You remember that? That's the judgment which turns there. So in 7(5)(a), the word may has been used. In 9(5)(a), the word shall has been used. And the judges say that, look, if two different words have been used in two different sections, therefore there is different legislative intent was there. Now there, the may was not construed as shall. But here the judges say even may can be construed as shall. So I think there is some dichotomy is there. But anyway, when Vidarbha is considered,
I will deal with it, Ashish.
I know. So I'm leaving it for the timing for Satwinder ji to deal. So I think I'm just leaving it. But I just wanted to point out that there is a difference. There is a certain dichotomy. Now, if the resolution plan, now this is another statement. Now, friends, para 52, 53, 54. These are three paragraphs which are really are very dangerous paras. If the resolution plan ignores the statutory demands payable to any state government or a legal authority altogether, the AA is bound to reject the plan. Now, how come the ignorance is coming? Let's understand this, friends. The judges say, the Supreme Court judges say that sales tax department is a secured creditor. Being a secured creditor, now they have to be considered, and they are operational creditors. There is no doubt they are operational creditors. Section 32B. Now I'm drawing the attention of my friends to section 32B. What does 32B say? 32B says that in case of operational creditors, some minimum amount is guaranteed to be given in the resolution plan. So the amount which is to be paid to the operational creditors in the resolution plan has to be compared with two more items. One, liquidation value if distributed in accordance with section 53. B, resolution plan value if distributed in accordance with section 53. So higher of these three has to be paid to the operational creditors. So there is a minimum guarantee to them. So now the judge says that here the sales tax department is a secured creditor. So now if you distribute liquidation value, then they will also get the money as per clause B, subclause 2. Because in subclause 53(1)(b)(2), if you read very carefully, the word which is used is secured creditors. So they say it does not make a distinction between secured financial creditor and secured operational creditors. So even if an operational creditor is a secured creditor, then definitely they are also entitled for minimum amount to be paid. So if you consider this, some amount was to be paid to the sales tax department being a secured operational creditor. You have not followed 53(1)(b). Therefore, you have not followed 32(b). Therefore, the plan is invalid. So this is the logic which is coming from the entire statement. So everything is turning from sales tax department is a secured creditor, being a secured operational creditor, 32(b), and 32(b) is to be read with 53. So this is the whole thing which is coming from. Now, let us look at this. So this, according to me, is a very sweeping statements which can be definitely be misused by the government. Let's read once again. If the resolution plan ignores the statutory demands payable to any state government or legal authority altogether, the AA is bound to reject the plan. So this is a direction has been given to AA to please reject it. So this statement can be used by the operational creditors or statutory authorities. So that is one of the sweeping statements which have been made. Now, this is another para 53, which is important. If the company is unable to pay its debts, which includes statutory dues to the government or local authority, and there is no plan. Now, this is a very interesting sentence. And there is no plan which contemplates dissipation of those debts in a phased manner, uniform proportional reduction, the company would necessarily have to be liquidated and assets distributed under 53, section 53. Friends, I read it 5 times to really understand. Dissipation of those debts in a phased manner, uniform proportional reduction. What the judge wants is that, look, if you are making payment to the secured creditors, right, then because they are secured operational creditors to the government authorities and the local dues, obviously they were referring to the sales tax dues under section 48 of GVAT, but they have generalized it. Statutory dues to the government or local authority. So the liquidation, that means the payment should be made to the judge, the payment should be made in a phased manner. That means it is known as uniform proportional reduction. So uniform proportional reduction should be there. That means everyone should be paid in an equal manner. So if you don't do that, then the adjudicating authority has to liquidate the company and the assets should be distributed under section 53. Again, friends, I would say that this judgment, this sentence, para 53, will be used by some people, but we will have to contend, we'll have to distinguish by saying that it applies only in the context of the facts of each case. Otherwise, somebody is going to create confusion, use this sentence and cause confusions. So this is what we have to really, really understand this. And the last para 54 is also very important, friend. The COC, which consists of financial creditors, cannot secure their own dues at the cost of statutory dues owed to any government or government authority, or for that matter, any other dues. Now look at the sweeping statement. First, it is a warning to COC that, look, you are sitting in the COC as financial creditors, and if you don't pay anything, any amount to the statutory dues or the government authority dues, and then they say, or for that matter, any other dues. Now here comes the confusion. So if they keep a major chunk with themselves, not paying to the statutory dues, and generally we have seen in most of the plans, statutory dues are paid only 5%, 10%, in some cases only 1%. And in operational creditors are also being paid 1%, whereas financial creditors are being paid 26%, 25%, or maybe more than that. But here they are saying that, look, if you secure your own dues at the cost of the statutory dues or any other dues, then there is a serious repercussions which are there. So they cannot do that. So probably they are giving a warning to COC. But I don't know now whether COC will be in a position to say, oh, then if equal distribution is to be done, then what is the purpose of Section 5? Then let us take the company into liquidation. So anyhow, this is also this para is also causing a lot of confusion there. And in any case, this was not an issue before the Supreme Court. I don't know why the Supreme Court dealt with this issue, but it must be read in the context of the statutory dues attaining the status of the secured creditor. To that extent, they are fine. If a statutory due attains the status of being a secured creditor, then a proportional payment should be made in accordance with 53(1)(b)(2). Well, that is fine. So nobody is denying that. Now 53, and they also have held that 53 does not override 48 of GVAT Act. Now let us understand Section 48, and then I'll come to this, right? And they have also said security interest could be created by operation of law. These two issues I mentioned earlier, but I left it. Let us read Section 48 of the GVAT. Now that's very important. It says tax to be the first charge on property. Remember the word charge which was used in 77? Remember the word charge which was used in definition of security interest? Here comes the conclusion by the judges. It says, notwithstanding anything to the contrary contained in any law, for the time being in force, any amount payable by a dealer or any other person on account of tax, interest, or penalty for which is liable to pay to the government shall be a first charge on the property of such dealer. So the tax, interest, and penalty owed to a sales tax department under GVAT Act is a first charge. Here comes the conclusion by the judge that, look, if it creates a first charge on the property, it can be created by operation of law. They say charge can be created by two modes, one by contract and second by law. So here law says it is a first charge. The moment it says it's the first charge, they become the secured creditors. Here comes that logic, friends. And let us look at the implication of this. Of course, Section 53 talks about the order of priority. So the judges have also concluded that, look, Section 48 and 53 are operating in different domain altogether. There is no inconsistency. So therefore, the question of 53 overriding 48 does not arise. 48 simply says that there is a first charge. 53 says that, look, secured creditors will be paid in this manner, unsecured financial creditors will be paid in this manner. So where is the clash between the two? This thing. To this extent, I agree with the judges also. But friends, let us also understand that, of course, was a VAT Act. VAT Act was no longer applicable. We are talking about GST. There is a similar section in GST Act also, Section 82. It also says tax to be the first charge on property, notwithstanding anything to the contrary contained in any law for the time being in force. But here there are some new words are there. Save as otherwise provided in the IBC. These words were missing in GVAT Act. Any amount payable by a taxable person or any other person on account of tax, interest, or penalty which is liable to pay to the government shall be first charge on the property. So even the amount of tax, interest, or penalty payable under GST becomes a first charge. But here there is a small difference because it says save as otherwise provided in IBC. So this section says I am subservient to IBC. But some people can say that, look, this makes a slight difference because in GVAT, this sentence was not there. So therefore, under this, if we use this, despite the fact they are secured creditors, now they will be paid under the head government dues, because government dues has a separate heading which is there, in which is given in clause number E of section 53(1)(e). So they say they will be paid at a fifth level because government dues are paid, regardless of the fact whether they are secured or unsecured creditor. So this may also cause some confusion. So my suggestion has been, and what we have to look for solutions also. The solution is, friends, if you look very carefully on 53(1)(b), the word is secured creditor. Don't you think it should be now rephrased as secured financial creditor? If we are wanting to give preference to bankers, so obviously we'll have to deal with it, secured financial creditor. Now, but this can arise, and then government dues, and then they can say government dues, whether secured or unsecured. They can write that in 53(1)(e) also. So two changes, if they are done, I think they will bring a lot of clarity. That's one part. But this could also, you see, bring in some kind of a dichotomy. Let me explain that, and then I will leave the forum for Mr. Satwinder Singh. The other point which is very important to be considered is that, look, supposing there are no financial creditors, there are no banks, there are no secured financial creditors, there is no loan which is taken by the company, but some security is charged to an operational creditor, and he becomes a secured operational creditor. Now, if you follow 53, which is the order of priority, then the poor secured operational creditor will be paid after the unsecured financial creditor. Look at clause number D. It says unsecured financial creditors, isn't it? So now here is a dichotomy that secured operational creditor is paid lower than the unsecured financial creditor. Now, what was that the purpose? Well, so therefore, to overcome that, what the government can do is they can really add clause number CA, right? After the employee's dues for 12 months, they can add clause CA, and they can write payments to secured operational creditors. Now, whether they want to include government dues here or not, that's up to them. If they want to include secured government dues, they can put it. Otherwise, they can clarify in clause number E, government dues, whether secured or unsecured. So I think these are the three things which if they are done properly, I think this will clarify. According to me, if you ask my opinion, if we go to the preamble says alteration in order of priority of the government dues. As compared to Companies Act, when winding up provisions were there, government dues were considered as preferential payments. Crown debts, they were paid higher than after the secured creditors, they were paid. But the situation has changed under IBC. We say that, look, they have to be paid even after the unsecured financial creditors. So that was the intent. So if we go by the intent of IBC, government dues, whether secured or unsecured, have to come in clause number E itself. That's my opinion. Of course, now the government has to really modify it. But please consider a situation where not the government, but any other operational creditor is a secured creditor, and there are no secured financial creditors, then poor fellow will also be paid lower than the unsecured financial creditor. So even to overcome that situation, I think I suggested that clause CA can also be added to cover secured operational creditors other than government dues. And in government dues, they can say government dues, whether secured or unsecured. So if these three changes are done in section 53, I think most of the things will be clarified. There will not be any confusion. Rather, we'll say that this judgment will be overturned. Or the second alternative is somebody files a review petition. Well, we don't know what is going to be the fate of the review petition. So friends, this was all about rainbow judgment. I will now leave the space for Satwinder ji to deal with the other judgment, which is Vidarbha. Over to you, Satwinder ji.
Thank you. Thank you.
Thank you, sir, for the session. The next session will now be taken by Satwinder Singh, sir. He will be taking the session on Vidarbha Industries Limited versus Axis Bank Limited. At the end of the session, he will be taking questions also on both the judgments. Mr. Satwinder Singh, sir, is a founder and managing partner of Ecom Legal Firm and was a former partner in Wesh Associates. A lawyer by profession, he is also a qualified company secretary, a registered insolvency professional, and certified associate of the Indian Institute of Bankers. He has extensive experience in handling corporate law matters, including mergers and acquisitions, corporate restructuring, revival, rehabilitation, and insolvency matters, joint ventures, collaborations, private equity, banking and securitization, takeovers, acting as legal advisors to IPOs, etc. Sir, you may now start the session.
This one.
Sir, am I audible to you?
Yes. Anu, is it my presentation is visible?
Yes, sir. Is it?
Okay.
It is.
Yeah. Thank you, Makhija Saab, for setting the tone. These two judgments, as you said, that's really created a lot of confusion. Rather, somehow I am feeling, is it unsettling the settled jurisprudence which so far has been created? I was wondering that, you see, there are three phases of IBC. The one phase is that admission stage, another is the CIRP stage, and the liquidation stage. For the last 2-3 years, I was saying that at least the issues with respect to the admission stage have been settled. The jurisprudence has already been evolved. And this over and above, then even the jurisprudence on CIRP also, we were presuming that has been settled. There are certain issues on that liquidation, but I think it is coming back to the admission stage when we are rewriting that whether whatever the jurisprudence developed so far, that has been really there, or a new law which has been written through the judgment of Vidarbha and the new law which has been written on the rainbow matters. And on the rainbow matters, Makhija Saab has already beautifully explained the issues involved, and there are many issues probably we can discuss on the panel discussion for about half an hour, when we will take it up half an hour, 35 minutes of the panel discussions on both the issues on the rainbow matters and the Vidarbha. But let me take you, before I develop on this judgment, let me take you to the say purpose and objects which was given when this bill was placed, so that we should be clear about certain things and the history behind it. If you see the purpose and context, it was saying the bill lays down a clear, coherent, and speedy process for early identification of financial distress and revival of the companies. And it's very important, the other lines, if the underlying business is found to be viable. So it's an early detection. And if the business is found to be viable, we are looking at a process revival of the companies to that extent. Now, I'll take you to the BLRC report. Just first paragraph itself speaks a lot. That is the executive summary, if you will see, very clearly written. That limited liability company is a contract between the debt and equity. As long as the debt obligations are met, equity owners have complete control and the creditors have no say in how to run the business. That's the first paragraph of the executive summary of the BLRC report. But when the default takes place, control is supposed to be transferred to the creditors. Equity owners have no say. That's a very important aspect on the basis of which the law has been framed. Now, let me tell you, yesterday the news has come that this judgment has come to the review, and the review is taking place before once the application has gone and other things. Apart from these two judges, other 5 judges, if they agree to this, they will place the matter. Now, what would be the fate of this? But right now, the law is what is provided in the Vidarbha. I don't know, after that review petition has been filed, what would be the fate? I leave that as it may, and seeing that, okay, we are discussing the Vidarbha Industries judgment as on date. Now, I'm just making it is, apart from these basics, if you see the provisions of the Companies Act, and there was provisions with respect to winding up, and in 271, that provisions with regard to the inability to pay debt, where the people earlier was using that okay, if there is inability, the person has not paid, you file the application of winding up and the winding up application will be admitted. It's an inability. They said, no, let's bring the concept of the calm period. And during the calm period, let the powers be given to the financial creditors through COC. They will decide the fate. And then, apart from inability to pay debt, the question of debt and determination of default had come. I will deal with the legal provisions also. I will deal with what is the facts, as Mr. Ashish Makhija had also given. It's important because when we have to discuss it, let us briefly discuss about the facts of the case. Now, this Vidarbha Industry, appellant, a power generating company, right, under the Electricity Act, and the Maharashtra Regulatory Commission, Electricity Regulatory Commission, determine the tariff. Now, under the Electricity Act, there is always a mechanism of determination of the debt, which is important part of how the dues has to be made for this thing. So as a result of certain developments from 2003 to 2013, a dispute arose between the appellant and this regulatory commission, which is, I would say, the MERC, on the amount of the final tariff. So they filed this, the regulatory commission MERC, they disallowed the substantial portion of the actual fuel costs as claimed by the Vidarbha Industry, that's appellant, and capped the tariff. The appellant went to the appellate tribunal of the electricity authorities, that's APTEL, which allowed the appeal and asked that, okay, appellant claims that a sum of 1730 crores is due to the appellant in terms of the said order. No, and then the MERC filed a civil appeal challenging the order. Appeal is still pending. Appeal is for the time being short of funds. No, the appellant short of funds, it's asserted the implementation, nothing else. And it then comes the Axis Bank. As a respondent, as a financial creditor, he moved the application under Section 7. Now, relying on this Swiss ribbon judgment, NCLT dismissed the applications and refused to stay the CIRP initiated against the appellant. The observation, and I'm just quoting it, the code, the observation would indicate that no other extraneous matter should come in the way of expeditiously deciding a petition either under Section 7 or under Section 9. The inability of the corporate debtor in servicing the debt or the reason for committing a default is alien to the scheme of the code. The authority is required only to see whether there is a debt and the corporate debtor defaulted in making the repayments. The fact of the matter is that so far the way I look at it is the concept from the net worth has shifted to the liquidity position. If you have a liquidity, you are serving the debt, no problem. The moment you are subject to the liquidity problem, you are starved of cash and other things, irrespective whether you are showing in the balance sheet. That was the law so far, and I'll take you to the judgments of the Supreme Court also in this regard prior to Vidarbha judgment came. Appellant filed an appeal before the NCLAT, NCLAT also dismissed that the flow of the legal process cannot be permitted to be thwarted on a consideration which are interior to the mandate of section 7(4) and 5. The appeal being devoid of merit is dismissed, and then the matter went to Supreme Court, and the appellant filed the appeal against the order of the NCLAT. Now, what was the issue? Unlike there were 3-4 issues in the Rainbow matter, there is only one important issue, is that whether there can be an existence of debt and occurrence of default are enough ingredients for emitting a section 7 application or not. So before I would say that, okay, we deal with this issue, let us look at the provisions of the debt. That means a liability or obligation in respect of a claim, and the claim definition is also provided, whether it is contingent, disputed, undisputed, that is there, which is due from any person, and then they divided the financial debt and operational debt. And it is very important because they have distinguished the financial debt and operational debt while dealing with this judgment, because they have distinguished 7(5) and 9(5) as may or shall. So financial debt I'm just skipping because that's a definition. Default means any non-payment of debt. So one is the debt, and the default is when there is a non-payment of debt, when whole or any part or installment of the debt has become due and payable. If you will see the claim, there talks about the due, but when there is a default, the term is due and payable. There could be something due, but it is yet not payable. That's not constituted a default. And the moment it is due and default, and the default and is not paid by the debtor, as the case may be, then they define who is the operational creditor and the operational debt. And operational debt is again defined with respect to the provision of goods and services, employees, and the statutory dues which have been given. Now look at section 77(5), which is very, very important when we have to deal with this aspect. It talks about, and where that distinction has been given. It says that 5 is where the adjudicating authority is satisfied that a default has occurred and the application under subsection 2 is complete, and there is no disciplinary proceedings pending against the proposed resolution professional, adjudicating authority may, and here by order, admit such application. So in the entire judgment, the discretion has been given between the may and shall, and the rule of literal interpretation has been applied to the judgment as regard the financial creditors are concerned. Is incomplete and any disciplinary proceedings is pending against the proposed resolution, it may by order reject the application, provided that adjudicating authority shall, before rejecting the application, give a notice to the applicant to rectify the defect in his application. Now, if you look at it, otherwise, if you see the concept and the statutory law, under section 7, there was no prior notice. It is only when the service, because of rule of applied that, okay, the opportunity of being heard should be given, right? And then they said that, okay, the one notice. So that means, but in operational creditors, there is a concept that, okay, first you give a notice under section 8, and if that 8, there is a dispute, then 9 will not be admitted if there is already an existing dispute and there are a number of judgments, but that should not be a feeble dispute and all that. So that is where 8 and 9, but 7, there was no notice concept, except the notice when you are making it is you have to serve it, and then the one notice which has to be given by the NCLT over a period that how the jurisprudence has been evolved to that. But look at section 9(5). Here they said that adjudicating authority shall, and I will try to, my view, I will give that that's my personal view, and that has to be not considered as a view of the institute or let it be in the review petition, which is to be argued for this, the adjudicating authority, that is in case of operational creditors. So it becomes mandatory to admit when these are certain criteria have been given that the application under subsection 2 is complete, there is no payment of the unpaid operational debt, invoice for payment to the corporate debt has been delivered by the operational creditor, no notice of dispute, there is no discipline, and all that under the regulation which has been given. And when you are moving the application by the operational creditor, there are certain checks and balances which have been given under 5. And when the court is mandated to reject the application, when certain conditions are not being met, then the court, the NCLT adjudicating authority, I would say, is supposed to reject the application. So that is, I would say, the question of this. But where that may, which is coming, whether that may has to be used as a literal rule of interpretation only with respect to the debt and default, or it's totally the jurisdiction which the adjudicating has the authority, even that if it is not satisfied, whether that satisfaction is only debt and default, which the adjudicating authority has to satisfy, or they has to satisfy from the financial strength of the corporate debtor. Otherwise, I think that's a principal question which is there, which is arising. But how the you see this judgment has come is taking it up. I'll just take you to certain settled jurisprudence so far in section 7. First, look at innovative and Radha exports. If there is a debt and default, it will be admitted. So that's first one. The moment the adjudicating authority is satisfied that a default has occurred, it's a Supreme Court judgment, the application must be admitted unless it is incomplete, in which case it may give notice to the applicant to rectify the defect within 7 days of the receipt of the notice from the adjudicating authority. Look at Babula Vardharaj. A debt may not be due if it is not payable in law or in fact. As observed by this court, the legislative policy now is to move away from the concept of inability to pay debt to the determination of default, and the default definition we have said when it becomes due and payable, right? And you are not able to pay at the time of this, even the principal or even that interest has not been paid, it will constitute as a default. Even a single default can take you to the adjudicating authority under the IBC. If there is a debt and default, it will be admitted. Indus Biotech. It has been observed by the Apex Court in any proceeding which is pending before the appellate under section 7. If such petition is admitted upon the adjudicating authority recording the satisfaction with regard to the default and the debt being due. Now, that's very important. It is the recording of the satisfaction only the default and the debt being due from the an application under section 8 of the AC Act 1998 thereafter will not be maintainable. Natural consequence of the consideration that has to be done. Now that's the. Now let's come to the interesting observations which has been given in the court, and as I said that there is only one issue which has been debated upon, and we have to just look at from that angle that what is the issue which is arising out of that. Certain interesting observations as pointed it out. I'll just give you that observation. Para 75 of the judgment. Significantly, legislature has in its wisdom used the word may in section 7(5)(a) of the IBC in respect of an application for CIRP initiated by a financial creditor against a corporate debtor, but has used the expression shall in otherwise almost identical provision. I am not sure whether 9(5) is identical to 7(5)(a) or not, but under this judgment they are saying both are identification provisions, where 9(5) talks about that you have to admit it if certain threshold criteria which has been given, that has been met, and you are mandatorily required to reject it if those criteria are not met and those conditions have been given. But they are saying that these are the identical provisions. That is the one part which we have to see, that IBC relating to this, but let that as it may for this. Para 77. On the other hand, so in the 75, they have gone for, you see, the rule of, which is the, and they said the first and foremost rule of interpretation is a literal rule of interpretation. The word may is used, you have to apply that. Now 77, on the other hand, in case of an application by a financial creditor who might even initiate proceedings in a representative capacity on behalf of all financial creditors, I think, even to my mind, even if the case has been filed by the operational creditor, it becomes a representative suit, not only even against the operational creditors, even who are the financial creditors. But the only thing is the constitution of the committee would be of the financial creditors. The suit becomes a representative suit against all the stakeholders. The adjudicating authority might examine the expedience of the initiation of CIRP, taking into account all relevant facts and circumstances, including the overall financial health and viability of the corporate debt. Now, all through, I was under the impression that the proceedings under the IBC are the summary proceedings. But suddenly what is happening now is that if you have to examine the witness, you have to examine and you have to take it, I don't think that when everything will go into that part, whether we will be able to even meet the threshold time limits, because then there would be the evidences and everything, and then the adjudicating authority has to determine, including the overall financial health and viability of the corporate debtor. Now, you all would be seeing that, okay, suddenly the net worth criteria, there may be that, okay, the entities have the assets criteria, but they are liquidity starved. The moment there was liquidity starved, those have been admitted. But suddenly now a new, you see, law has been emerged through this judgment, unless and until it is reviewed by the Supreme Court. The review application, I think on 19th of September, the review application has been listed. Let's see, and we will wait the outcome of the review application. Then let's come para 78. The legislature has consciously differentiated between the financial creditor and the operational creditor, as there is an innate difference between the financial creditor in the business of investment and financing and the operational creditor in the business of supply of goods and services. Financial creditor is usually secured and of much longer duration. Such credits, which are often long-term credits on which the operation of the corporate debtor depends, cannot be equated to operational debts, which are usually unsecured, of a shorter duration and of lesser amount. That means, what they are talking about is that if the operational creditors would have filed it and they had defaulted it, and the debt and default was admitted, the application, they would have admitted it. But since these are the financial creditors, the court has to see the financial strength and the nature of business of financial creditor. That cannot be compared that of an OC engaged in supply of goods. The impact of non-payment of the admitted dues could be far more serious on an operational creditor than on a financial creditor. Now, in this, I don't think that how the law will be evolved if those judgments that the operational creditors we are talking about under 53, how they will be paid to the liquidation value, and we all see that what sort of a percentage the operational creditors are getting and what sort of a percentage of the bid value which the financial creditors are taking it up. That's the issue which will definitely come up in due course if those observations continue in this judgment, which are important to be looked into. Another important aspect, para 81, which talks about is the title insolvency and bankruptcy law, makes it amply clear that the statute deals with and tackles insolvency and bankruptcy. It is certainly not the object of IBC to penalize solvent companies temporarily defaulting in repayment. And what I read to you, what is in the bill, what is in the BLRC, that even if there is a single default, shift from the ownership to the creditors, let the creditors take it. I think it has again gone into that, the temporary default in repayment, what would be the permanent default and what would be the temporary default. Again, it would be subject matter of interpretation. One has to see to it. I had seen many cases where the asset base is too high, people have invested it, and in the books, the net worth is coming. But because of the default in the payment of 2 or 3 installments and other thing, where the financial creditors have moved, it has been admitted. And even a I would say, substantial haircut taken by the creditors, and new resolution applicants have come up to that extent. So my view, I'm just looking at it, is that how it is to be seen. If that would be the case, is it a case where we have to rethink even on the 29A? I'm just, you see, questioning to myself that, okay, if that is the view which is to be merged both in the rainbow and both in the this judgment which has come in the Vidarbha, I think these are the issues which has to be pondered upon. Then coming to another interesting observation, adjudicating authority failed to appreciate that the question of time-bound initiation and completion of CIRP could arise only if the companies were bankrupt or insolvent and not otherwise. And the bill says that if the underlying business is found to be viable. Now we are talking about, we know that, okay, bankruptcy, insolvency, it's a process which leads to dissolution. But I think then what would be the concept of CIRP when we are talking about? Moreover, the timelines start taking only from the date of admission of the application for CIRP and not from the date of filing of the same. I am not going into that part, that from when this CIRP process has to be started. But there are other related issues which are being taken care for this financial creditor. We know that, okay, the application has been filed. In the meantime, financial creditors have, you see, made certain adjustments, priority and other thing. And on those issues we are fighting. We had a case that application was filed, one of the bankers in our matter. In the meantime, the order had not come. And in the meantime, they appropriated the funds lying in the accounts of this thing to their debt. And we said that, okay, you can't appropriate it. When the order has been reserved and that you see the date of filing from this thing, you can't say that you appropriated, and the court held, the NCLT held, and even for the Supreme Court held that, okay, no, giving directions to the bank to remit the funds back and let it be funds of the company, you cannot appropriate it. No, that's what I'm just making it here, is that this judgment has really unsettled a basic feature which used to keep default as a fundamental criteria, inability, considering the recommendations which I'm just making it is. If you look at this Swiss ribbon, which said the laid out that endeavor should be made to dispose of the matter in a time-bound manner. The trigger for a financial creditors application is a non-payment of dues when they arise under loan agreements. It is for this reason that section 433E, which I was just saying of 96, has been replaced by the code, and a change in approach has been brought about. Legislative policy now is to move away from the concept of inability to pay debts to determination of default. The said shift now, is it that, okay, we are saying, in though a minor reference of Swiss ribbon given in this judgment, but in some different context, but they are not given the exact what is even in this Swiss ribbon. And as my friend was saying, in rainbow judgment, there is nothing as regard whatever the government has put it, that has been put it in the judgment. Whatever the arguments from the financial creditor side, what were the arguments from the other side, that has not been taken. And similarly, if you will see, there is hardly any you see observations given, and some judgment on the basis of both the arguments, taking it, distinguishing the points, and then the decision has been taken. Somehow it is missing here. And as is discernible, the preamble gives the insight. No, they are also talking about the preamble, a code for reorganization in solvency. And we are saying that whether this is the, it was not the object, the financial creditors have to be taken. I think entirely, I would say the contrary judgment has come, which the judgments earlier delivered in Swiss ribbon and the innovative and other judgments, that has come to this. Now, I would say, and probably we have to put it, whether the questions issue that arises for consideration in the entire judgment is whether the existence of debt and occurrence of default are enough ingredients, or we have to really go for a full scale observing that the financial creditors have to see whether financial health is a defense towards defending 7 applications. Right now, I was discussing with many of the real estate companies. In their books, the assets are there. If I would see the financial health, the solvency criteria, I would say, yes, they are meeting the solvency criteria. But I think if this judgment continues, probably there would be many applications will be filed on this basis. That has to taken, and whether this judgment has taken away the summary jurisdiction, which I am posing it, these questions to my very, very learned friend Ashish Makhija, who has, I think, given enough contribution to the IBBI for even setting up the exams, for even writing the books, and helping IBBI to evolve a law and, you see, making it to that part. So with this, probably I would ask Mr. Ashish Makhija that, okay, if we can discuss certain issues on the panel discussions and other things for 15-20 minutes, even on his judgment and the judgment which has come on the rainbow matter, and then we can discuss it. Is Ms. Makhija there? Hello?
Yes, sir, I'm there. I'm here only.
Right, sir, right. So, sir, I think I've given a brief because there was only one issue, but I saw that there are even many instances which I thought that let me quote the paras of the judgment which are there. And when I'm reading, I am thinking that, okay, it is unsettling the settled position so far. Well, I would see to it, but the questions which are arising from the presentation which you have given on that rainbow, though I have read it with very much interest, but let me just take you, sir, to section 53. Just give me the judgment. 53. Makhija sahab.
Yes, sir. Go ahead, sir. Go ahead.
So if you take it to 53, which I am just making it is, which gives the waterfall mechanism.
Correct.
Now, if you see this 53, sir, which 53 talks about the distribution of assets, and basically in rainbow also they are distinguishing on that security interest and all that, which we are just taking it as. So I will take you to the definition of security interest also. But before that, 53 we can also deal with. Now, the legislature, as I said, I'll again take you to the BLRC report. Sir, first I'll take you to the BLRC report. Where they said that the intent was, so let me take you the BLC report executive summary. I'm just reading, sir. The committee has recommended to keep the right of the central and state government in distribution waterfall in liquidation at a priority below the unsecured creditors. That's arising out of that BLRC, sir. In addition to all kinds of secured creditors for promoting the availability of credit and developing a market for unsecured financing, in the long run, this would increase. So idea was that so far secured creditors, if you can go for a revival, right? Probably the government can in future again earn it. That was the concept which was being given the way I understand. Now, if you see 53 talks about financial debts owed to unsecured creditors. Then the word is the following dues shall rank equally between amongst the following, sir. Right? 53E1. I'm just emphasizing only on that amount. Any amount due to central government and the state government. That's a one part. No, the word any is not defined. Right? And I thought that let me go through the dictionary meanings. Where the word any is used in a statute, then it signifies widest connotation of a particular thing. Merriam-Webster online dictionary, any means one or more, one or some indiscriminately of whatever kind, used to indicate without restriction or some without reference to quantity or extent. That's a one part. Now, when the word used was any, was it not that the legislature had intended that, okay, it should include even a secured or unsecured or whatever kind it is, there under that waterfall mechanism, it should come. That's a one part. I would like to have your viewpoint on that. That's a one part. Then I will come to the security interest. I think both are related. Now look at the security interest definition, sir. If I, section 3, subsection 31. Now, here the security interest, which they said, the two observations I have, which I would like to take your inputs on this. And then I will go to the Vidarbha also. Then there are many questions arising to me. I'm debating to myself on that rainbow because there are 4 issues which have emerged out of that judgment. But coming to this, whether the secured creditors have to be taken or not. Now, security interest means a right, title or interest or a claim to property created in favor of this for a secured creditor. I think that's the important part. The word is by a transaction, sir. The word is by a transaction. Now, the transaction has also been defined, sir. Transaction is subsection 33 of 3. Transaction includes an agreement or arrangement in writing for the transfer of assets, funds, goods or services from or to the corporate debtor. No, one can say it talks about includes, but I think the rule of a justum generis should apply also. Right, to that extent. My view is that, okay, that security interest has to be taken only when there is a security interest created by a transaction. If I have to come within the realm of this to put it to this, that's my observation. As I said, that my observation is my observation. Maybe that your observation has to come. So let us first, sir, discuss on these 2 aspects. And the third related issue, which I'm just making it is, sir, is that all through under the Companies Act, I said that, okay, if the charge is not created with the register of companies, it will be deemed for the third parties as an unsecured debt, right? So it will not be there because, and in that case also, because under the Gujarat VAT authority, they said it is a secured creditors. If that would have been there, they would have filed the charge and to a third party, it would be there. So what is your view on this, sir? I think that's an important part. I know that you are much more learned than me, sir. And
I think
But-
we are all waiting and we are trying to understand. We are all
Yeah.
learning. So on the first aspect, sir, when you are pointing out those BLRC and also emphasizing on the word any, well, there is no quarrel about it. Let's understand and be clear. The intention of BLRC was absolutely clear that look, insofar as the government dues are there, they have to be one step lower even than the unsecured financial
Yes.
creditors. There is no quarrel to that. In fact, as I mentioned in my deliberation also, that it is also reflected in the preamble.
Yeah.
The preamble specifically says, otherwise, why the preamble should say? Preamble
Yeah.
says alteration in the order of priority of payment of the government due.
Permanent.
So therefore, intent
Yes.
was definitely there. Now,
Yeah.
coming to the word any, so here comes, I don't dispute that, look, as far as the government dues, whether secured, unsecured, they should fall under clause number E, there is no doubt. But how the doubt has arisen is because in clause number B2, we are using the word secured creditor only.
Yes.
Had the government used, because you see, if you look at 53, because you refer to 53.
Yeah, because it doesn't talk about the financial creditors. Yeah,
Because if-
53. Yeah,
if you look at
it
50
talks about the secured creditors.
no, if you look at D clause,
Yes, yes. I'm just coming.
very specific. It says financial debts owed to unsecured credit. There they are using the word financial. So therefore, nothing stopped the government by using the word secured financial creditor in 53(1)(b). So therefore, the confusion has arisen. So just to clear this air, and also the priority of the government that look, it is in clause number E only. Two clarifications are required, amendments are required. We must add the word secured financial creditor now in clause 53(1)(b). So we must add the word financial there. And lastly, in clause number E, any dues of the government, then we can say whether secured or unsecured, just to clarify a little bit more. So I think that will end the whole controversy. This will overturn this judgment also and the effect of this judgment also. That's one point. Two, coming to security interest, sir, see, if you look at security interest definition, sir, according to me, it is in two parts. One is a meaning part and second is inclusive part, which is only illustrative. Now the word charge is appearing in inclusive part. So according to me, it has nothing to do with the transaction. Transaction word is appearing in the meaning part of it, which is the first part. Second part says, and includes mortgage charge. So whatever charge is created, whether it is created out of a transaction or out of another thing or operation of law, well, it does not say so. So inclusive means it is including even the by operation of law also. So, and in any case, if you go to the meaning of word transaction also, sir, the transaction says transaction includes. So again, it is inclusive. So inclusive, we all know that it is only illustrative. It is not exhaustive definition.
Yeah.
So that's my second, comment on this. The third is, as far as the unsecured creditors are there, particularly the charge which are not created under 77(3), I also mentioned that.
Yeah.
But here also, look, Satwinder ji, I also wanted to have your opinion on this on 77(3). Let's read it together. It says, notwithstanding anything contained in any other law for the time being in force.
Yeah.
The next words are very important, sir. No charge. If you want, sir, I can show it on the screen. Because
if you can show it, sir.
in my presentation, I'll just show that. So that it benefits all the.
Yeah.
Just give me a second. Yeah. So this is section, 77. I think it was there.
It could be the company's head.
Yeah, here comes 77(3).
Yeah.
Okay, I just wanted to read this. Notwithstanding anything contained in another law for the time being in force, then the next words are very important. No charge created by a company shall be taken into account by the liquidator. So here the emphasis on charge created by a company. Charge can be created by a company by way of a contract.
Yeah.
So is it only including the contractual charge, or is it also including the charge which is created by operation of law? So now somebody as a lawyer can interpret both ways. One can say, oh, 77(3) only includes the charge which is created by a company through a contract only.
Mm-hmm.
Because this is not a charge created by the company. This is a charge created by operation of law.
Mm.
So they say operation of law charge is not required to be registered. And if it is not required to be registered, whether registered or not, that's a second controversy. But if not registered, it will still be binding on the liquidator. So one can always have that opinion also. But in reading, let's apply the literal rule first. Let's not go into the rules of it. Literal rule, according to me also, I also read it like this, that any charge, whether it is by operation of law, whether it is by contract, it must be registered. If it is not registered, then the liquidator has to ignore that charge. Now, looking at that, so if the company goes into liquidation, if the charge is not registered, then what happens? Then the state dues are not considered as secured. They will automatically comes under unsecured creditors. So those issues are still open. I think we'll have to really look into those aspects.
And the only thing is that the problem which comes, I am seeing it as a transactional lawyer also from that aspect, because when we talk about the security charge and other things, right, that means otherwise the due diligence, normally the charge report comes that, okay, these are the secured, other are unsecured. And the government dues, if we'll start, you see, this provision is, as you were rightly said, under the GST law. This provision of the first priority is even under the Income Tax Act, and probably there would be a whole lot of the other laws. I think it is going to open a Pandora box. To my mind, if we will continue this, I am seeing not only with respect to IBC, probably if we are looking at it, then we'll be probably seeing it from the different angle for that part.
In fact, sir, on this aspect, there are many more complications which are bound to come. Number one, under section 52, the relinquishment of charge is required. Now, having said that, first, all IPs will have to look at all these statutes now. Sales tax laws, whosoever, assuming 5 statutory authorities and government file the claim. Now they will ask them, look, under which act you have filed the claim? Read that act first. Therefore, it increases their job. Number one. Number two, having said that, supposing the company comes into liquidation, they will ask for the relinquishment of the charge under 52. Because if the relinquishment is not there, then how can he take the custody of the assets? That is going to create another. Now, third issue. Satwinder ji, you remember when we appear in the company code, and I was the standing counsel for liquidator in Delhi High Court. There, we also face the same issues many times. Now, but there is one more thing which I want to bring it. In some cases, we noticed as official liquidator that charge was not registered. But under surface, you remember that they were not relinquishing, and they said, we will sell it on our own, Mr. Official Liquidator, you lay your hands off. So whether charge registered or not registered, all these companies were taking over the assets, despite the fact the charge was not registered. But as official liquidator, we never raised an objection. We said, oh, under the Surface Act, you can sell it, whether charge registered or not. So there is a controversy between Companies Act and even Surface also. So, and in fact, there is a judgment of Honorable Supreme Court recently only, I think in April 2022, which they have very clearly said that Surface Act overrides even the Customs Act. So if those kind of judgments come, but they are not in the context of IBC versus Customs Act or IBC versus Sales Tax Act. Here the judge clearly says there is no clash between 53 and 48 because they operate in different domains. So this is the whole thing. Of course, a lot of clarifications are required.
Sir, thanks. Sir, I would like to say one thing here, because why this anomaly has arisen. This controversy has arisen due to anomaly in the legislation itself, as explained by Makhija Sirji and Satwinder ji. And I remember in first parliamentarian, if you'll see the history of Indian Constitution, first parliamentarian, 80% parliamentarians were lawyers. And that time, there was less controversy in the any legislation, less anomaly, less amendment, less dispute. But gradually, by this point of time, that parliamentarians reducing the number of lawyers, and then nowadays, if you'll see, there are less than 2%. Parliamentarians are lawyers, and due to this thing, these anomalies are existing in this legislation. And
my friend, please I think please understand this. We are not going by the wisdom of the parliamentarians right now or at the earlier stages. So this is a law which has been approved. Let's respect that law and we can
I am
discuss it on the
respecting
other.
the law, but I am telling the why
But you
anomaly
see,
has
those things are, it's a, whether there is an anomaly or not anomaly, or there is a, you see, there is a new interpretation has come. We are debating it. What was the intent and how it is taking? That's why I thought that, okay, let me take you to the BLRC and to the preamble given for when the bill was passed. Makhija Sahab, that's another point which I would like to take it up with you, is when you said that 238, to the extent it is contradictory to the provisions. That was this. But your point is to some extent it is not contradictory. Do you think that, okay, the 53, it is not contradictory? The section 48 of the GVAT is not contradictory to that 53, and to the extent that is contradictory, and 238 should prevail. If I go to the innovative judgment also, sir, in the innovative also, the position was that they said that, okay, the central legislation will prevail over the state legislation, if you recall, sir. The second was that, okay, they said that IBC is a subsequent legislation, it will prevail. The only thing is, if the differentiation here it is coming up is, they are saying there is no contradiction, but to my mind, if I say that it can still be construed as a contradictory qua 53 as far as the waterfall mechanism, then probably we will say 238 will apply. What is your view?
Okay, I think well said, because in innovative, sir, if I remember correctly, Justice Nariman has clearly written that there is a moratorium clause in that particular Maharashtra Relief Undertaking Act.
Yeah,
There is a moratorium clause under IBC.
that's
So
what I meant.
therefore, there is an inconsistency. Therefore, IBC overrides, being a parliament law, that is a state law. This
State
is a
law. Yes.
Article 254 and all that. So he considered that. And he also considered what is they fall in which list and what
Which
is the
list?
number in the list and all that. So
So
there was,
that's what I am recalling that judgment to that extent, because they're saying it is another part they have taken it innovative, that's a subsequent legislation, that's a prior.
that is also there.
And if I draw a parallel to this, I think it is emerging as the same as the GVAT and other thing. I'm just.
I slightly differ on that. I'll tell you why. There is no quarrel that this is a central law, that is a state law. Central law should prevail. There is no quarrel to this proposition. There is no quarrel that IBC is a later law. It should also prevail over the earlier law, because if in a later law, the parliament is saying, notwithstanding anything contained in any other law, obviously they know that what the law existed earlier. So that's the subsequent legislation. But here, the issue is under section 48 of GVAT, it only says it creates a first charge over the assets of the company or the property of the company. Now, section 53 does not deal with what creates a first charge or what creates a second charge. It only deals with how the money is to be. That's all.
So it created to some extent the secured creditors and unsecured creditors, I would say.
Only the confusion.
That's the only issue.
Yeah, the confusion which is arising again. 53(1)(b), where they've used the word secured creditor. Now, if they say secured financial creditor, it will solve all problems for all times to come. And in the government clause also, they should say government dues, whether secured or unsecured. End of the story, sir. After that, I don't think the controversy will be there. This judgment will be effectively overturned. Or review petition is filed and we don't know what is going to be the fate of that.
So, sir, there are, I think RPs attending this, basically this, and the kind of observations which have been given in relation to the RPs, what they are duty bound to provide. Correct. And I am representing one of the resolution applicant. Let me tell you, I am writing it to this thing is because their process memorandum, they said that, okay, you provide this by way of affidavit. What is your plan value? You have to give that, okay, to the secured financial creditors. And there is no mention of secured operational creditors. Now, after this judgment, that process memorandum, whether they have to revisit it, whether they have to provide it, because I know that, okay, there are hundreds of crores of the litigation of the government dues, even on that VAT and other thing. When I'll start looking at that, probably again, I will say that, okay, they pursuant to this judgment, they will fall within the secured creditors.
Correct.
Now, as a resolution applicant, I am bound to pay a certain amount. And in one of the judgment, if you see in the NCLT, where Justice Mukhopadhyay had said that it is the resolution applicant to decide to whom it is to be paid and whom it is not to be paid, right? But on the contrary, they said that Section 30T, it complies with the provisions of the law. If I say that under 53, it's pari passu, that means you have to give it, then how the RP has to satisfy that aspect? That's a one question. And what would be the fate of the ongoing matters which are going on, sir?
But
are they going to revise the list of the secured creditors and all that? That's the two questions, because I am always looking at your...
Sir, para 53 is a little dangerous in this particular rainbow, which I mentioned earlier, because the words which are used are very, very confusing. It says, if there is no plan which contemplates dissipation of those debts in a phased manner, which means uniform proportional reduction, then the company would necessarily have to be liquidated. So now what the judges actually want is that all the secured creditors, including the government dues, should be paid in a uniform proportional reduction manner. So this is what is there. And if you deny that, then it has to be liquidated. So therefore, because they have used the word government or local authority also. I think to overcome this judgment, as I suggested, those two changes have to be made. Otherwise, this is bound to cause a whole lot of confusion. And maybe it may open a Pandora box for the previously decided cases or the appeals where the appeals are pending.
So, sir, again, in my judgment, I had quoted out this thing which was equally relevant for Rainbow, which I was just looking at it, is the definition of operational creditors.
Right.
And I purposely added in my presentation that in the operational creditors, they said there are three kinds of creditors, and it was there. One is against the supply of goods and services. Second is the employees. And the third is the statutory dues, the common dues.
Correct.
Now, let us say, when we say that unequals cannot be paid equally, are we creating a class within the class and we say that the equals can be paid unequally as operational creditors? Because you are distinguishing the operational creditors, even the statutory creditors, a class within the class, I would say, that where there is no such provision, but they are statutory creditors, you will say that they are unsecured creditors, they waterfall. But there is under the laws where there is a specific provision like Section 48, which is coming it up. Is it not that, okay, we are creating something differently out of these judgments?
Sir, I would say that, look, insofar as financial and operationals are concerned, they were more relevant for CIRP purposes. Insofar as liquidation was concerned, we had to see which one had a first charge, which one had a second charge, which had no charge. So probably secured and unsecured creditors were more relevant for liquidation purposes, rather because you don't require distinction for operational and financial in or liquidation. But the government, because they wanted to make payments to unsecured financial creditors earlier than the government due, so therefore probably there the clause number D, they insert it. But I would say, sir, as far as operational and other things are concerned, they operate in different spheres. Secured and unsecured has different definitions. So even an operational can also be secured, sir. Today, sir, supposing I am an operational creditor, I supply you goods. I give you an order for supply of the goods. Supposing I've supplied goods, but you'll make me payment. So I'll say, okay, you give me collateral. I can ask for that collateral even in supply of goods also. So I can mention that does not matter. I've got priority now. So I'll get earlier money than anybody else in my waterfall mechanism. So I think these two issues are slightly different, but also connected to some extent.
No, why I'm saying is, sir, that is where saying the how RP has to satisfy, because they're saying that 31, where there's a reference of 53, that the plan is given. Now, if the RP has to determine it, whether the government dues as a secured creditors, then they will say that, okay, you provided whatever you have to give. To make a distinction that, okay, whatever has to be given, but the priority is that the equal, you have to rank pari passu with the others. So that's a dichotomy, which I personally feel is going to arise. And those who are the resolution professionals, they also have to see. And those who are the liquidators, in any case, it will come to under 53 squarely. But for resolution professional to see that the plan is in compliance with the every provision of law, then again they have to take a reference of 53. Am I
Sir,
audible?
you're saying the problem will arise. I'm saying problem has already arisen.
Yeah.
You're audible. So I'm saying the difficulty has already arisen. Now today, so let's conclude. RPs are supposed to check all laws to see whether it creates a first charge on the property or not. All statutory. This is first aspect they have to look into it. If they are treated as a secured creditor, other than financial creditor, supposing by statute, then they must see that under section 32B, the operational creditors, some minimum value which is assured to them, 3 limits are there, and 2 limits refer to the 53 section 53. So please make sure that the minimum amount which is being paid to the secured creditors, including the government dues, must be also provided. Otherwise, it will be a non-compliance of the provisions of section 32B. So it is going to create a whole lot of problems. That's why I'm saying immediate amendment is required in this case. And I'm sure IBBI is working on it. That's my news. IBBI is already working on it. So they have already started putting up a note, and I believe this is going to happen very soon. Rather, I would say ordinance may come on this particular aspect.
No, that's why I'm saying is there is the one more questions to you, then another larger question I will see. The one more question is the timelines of directory or mandatory. Now,
Right.
if you look at the Surendra Trading Company judgment, Supreme Court judgment, that's Kamalpat Jute Mills. They said the Supreme Court in its judgment specifically mentioned certain sections.
Correct.
That it is 75, 95, 10-4, where it is only in relation to the co-adjudicating authorities.
Correct.
The way I read that judgment, I was thinking that as far as the other limitations, be it under section 16, regulation 6, 15, what is submission, 3 days, 7 days, 90 days of the commencement, all that are mandatory, but adjudicating authorities have been exempted because they are performing this. But here it's a sweeping statement, sir.
Absolutely, sir. Absolutely.
It's a sweeping statement that all timelines are directory and not mandatory.
Sir, it is going to benefit to RPs also.
No, that's no. I'm just making it.
Because IBBI is issuing show cause notices today that you have not complied with the timeline. Now IPs.
No, they will.
These are directory and not mandatory. So don't prosecute me.
One more question, sir. We need to debate it.
Right.
And I don't think I will. But the time is already going to be over.
I think we leave some for this.
Yeah. So one more question, sir. This judgment, this matter has been argued by. I am just thinking maybe it's again my views, not the institute views and other thing, but I'm taking it on this thing because this matter has been argued by the Solicitor General, Mr. Tushar Mehta. I am thinking, is there any change of mind by the government that they would like to protect the government dues or something? What do you think? Personal level, not the institute again. I'm just.
I'll mention that, sir. I don't think
because
there is. No, sir. See, let's understand, sir. So as a lawyer, you and I, including the SG. Now, what they have to do? They have to protect their client. So they were working under the brief which is given to them.
Yeah.
I don't think it expresses the intention of the central government or the parliament. I will not.
I don't know.
Now, supposing IBBI hires him
to
file a petition, in fact, he will argue from that side now then.
No, I'm happy that in the review of Vidarbha, Tushar Mehta's, the Solicitor General is filing the review.
Right,
At least I'm happy to that extent. I'm very happy. Otherwise, I was thinking कि यार इस यदि ये दोनों judgments आ जाएंगी, sir, what would be the fate of this law? I was more concerned about this thing.
Satwinder ji, this is what I pointed out. Look at the judgment. If you have read completely Rainbow, which I'm sure you must have, where is the opposite argument?
There's no, don't know me.
All sentences, ASG says this, SG says this. No, there is no opposite argument. I mean, who argued? I don't know. So I will say effectively it was a one-sided argument, ex parte kind of a thing which happened. I don't know how it has happened.
No, after reading these two judgments, I was telling my other colleagues, start looking for other opportunities, I don't know the fate of IBC.
No, I think we should not go to that extreme. I'm not really worried on that. But this is a disruptive judgment, no doubt about it. Disruptions, sir, give you a chance to develop also, to
Yeah,
give
yeah,
a...
yeah. No, I think that's...
That's why we are debating, sir. Otherwise, why will we debate today?
Yeah, yes. And it gave us the opportunity to debate again, to read the law. Maybe that's okay.
I think, sir, can
That's
we...
fine. Yeah, we can take some questions, and maybe because I have to go for another meeting, I'd request
Yeah, can I come in, please?
Yeah.
Yeah, go ahead.
Yes, sir. Yes.
Please
Yeah,
just...
good evening, Ashish ji. Good evening, Satwinder ji. It's
Sir,
been
but
very
very
thoughtful
brief,
presentation.
Mr. Sood, that's the only request.
Okay. So just one question. In one of my cases where I was named as an IRP, Section 7 application by State Bank of India, the matter was before NCLT, and NCLT rejected. Allowed the both the parties 6 months time. Based on Vidarbha industry judgment.
You are talking about recent Indore judgment?
Yes,
Yeah,
that's right.
Vidarbha.
That's
Okay,
right.
okay. In
So-
fact, let me tell you, Mr. Sood, before you proceed, I
Yeah.
tried to use that judgment before NCLAT also.
Oh, I see. Okay. No, but do you think it can be challenged before NCLAT? Because this here is a case where the dues are outstanding for more than 8 years. The company has been in default for 8 years.
Mr. Sood,
And
I've
to say that it's a temporary default.
Mr. Sood, I've gone through the judgment. It is a good case for challenge. I can say you that. Please do that immediately.
No, but it's for the bank to do that. But bank may not be interested because they would be expecting a settlement. So maybe they don't challenge it. But otherwise, I think this is a case where the company has been default for so long. How can you say that it's a temporary default?
Either you reject or you accept. You cannot keep it in abeyance for settlement. That's not the adjudicating authority is expected to do. You remember there was one case in Mumbai when they referred the matter to arbitration and Supreme Court came down heavily. Says what nonsense? You cannot refer the parties to arbitration. So this is like that only. This is a mediation. So I think this is not a good judgment to follow. But at the end of the day, it follows Vidarbha. Vidarbha to a larger extent, which I also try to use. And what was the reaction of Justice Ashok Bhushan here, who is the chairperson? He said, Mr. Makhija, don't quote this judgment to me.
No, right now, Makhija Sahab, at present it becomes a law for the time being. I know that it is subject to review. I think let's wait for outcome of the application which is listed on 19, right?
Yeah.
And I think then it would be better to discuss on this issue.
Yeah, absolutely.
Thank you so much. Thanks.
Sir, good evening. I have a question. Sir,
Yes,
in this
sir.
Rainbow paper case, particularly, what about the applicability of section 238 and then amended section 238A, which says that if there is any inconsistency in any other law, maybe state or central, the provision of IBC would overriding. So whether that was not really applied in this case, because ultimately state government dues or any other act will not be would not be dominant on in the IBC, particularly with reference to section 238 and 238A. So your views, sir, on that?
Sir, I'll tell you, so far as 238A is concerned, I think we can't rely upon because it only talks about law of limitation to apply to IBC. That's the third section. Then coming to 238, sir, if you read the sentence, it says, in case there is inconsistency between IBC and any other law, then IBC will. So let's look at the reverse side. If there is no inconsistency, then there is no question of one law prevailing over the other. Here, the Supreme Court says there is no inconsistency between Section 48 and Section 53. Section 48 deals in a domain whether a person is a secured creditor or not. 53 deals with the priority of payment. That's all. So therefore, there is no inconsistency to that extent. Sir, in this connection, I can only refer you one case. You remember that Macquarie Bank versus Shilpi Cable case?
Yeah.
Where Justice Nariman said he compared Advocates Act with IBC. And he said there is no inconsistency. Even advocate can also send a demand notice. So it was brushed aside. despite the fact that an argument was taken that 238 will override IBC. So I hope I'm clear on this. Satwinder ji.
No, the only that I'm just seeing it is, sir, is the just a little deviation which I'm just making it is that so far the Justice Banerjee has said that okay, there is no inconsistency to that part, but maybe that okay, because of a gap in the provisions of 53 and other thing, it talks only about the secured creditor, not the financial creditors, right? Now secured creditors include the financial creditors and the operational creditors as regard the priority of payment is concerned. Now as you rightly pointed out, that if they said secured financial creditors, probably they will still be there, or where the word any is used, either they would have interpreted in that way that any includes both secured and unsecured to that extent. But if we go with the history, the philosophy behind bringing in the IBC, I think to that extent, but so far the review of Vidarbha has been filed. I don't know whether this application to that extent, but I'm not merely concerned about on that issue which you are saying the IBBA is taking care. As I said, that there are many other observations or the decisions or the judgments which have come that may not be misused, because if a partly it is taken and review is not filed on certain other observations which I had pointed out, could be that okay, it may lead to another chaos to that extent.
Correct. I think, sir, we can take one question in the chat box by Mr. Yogesh Gupta. I think he has raised a very interesting query. Now he says that, look, insofar as first charge and second charge is concerned, what is the priority? Because the word used is secured creditor. So
Yes,
now, whether it is a first charge holder or the second charge holder, who will get priority under this? Now, Yogesh ji, Satwinder ji, if you permit me, I can answer that.
Sure, sir. Sure.
My answer is this. You are absolutely right when you say this, because there is a lot of confusion in IBC. Now, let me take you to the first Insolvency Law Committee report. After BLRC, Insolvency Law Committee gave its first report probably in 2018. In that, this issue was raised by the bankers to them that, look, there is no clarity insofar as the first charge and second charge is concerned. The committee wrote in its report that, look, there is no clarification which is required, because because there is no clarification which is required, so we will not deal with this. Now, later on, in the second report, which was in February 2020, and of course, it got buried because of COVID, because the COVID started, so nobody looked at that report. In that report also, again, the same issue was raised. And there the committee recommended the Ministry of Corporate Affairs that please amend the law and add an explanation in relation to the first charge and the second charge holder, so that complete clarity is there. But somehow or the other, that report was buried because of COVID. I think it has not seen the light of the day. But I think absolutely right. Say first charge, second charge holder, there's a lot of confusion. Currently, what is good now, and there is a second view also. I just want to mention very quickly. They say that, look, if you relinquish the charge, first charge holder, and even the second charge holder. So when you relinquish the charge, then you are without charge now. And you tell the liquidator, Mr. Liquidator, you sell the property and give me an order of priority. And order of priority is all secured creditors. So first charge and second charge holder become equal. So here comes the answer under section 52, that if you are a first charge holder and there is a second charge holder also, to obviate making it part as of the liquidation estate, you should always take the property and sell it on your own. Because in case you relinquish, because now you have relinquished, the moment you relinquish, where is the question of first or second charge? So that's a second opinion, which argument which comes. So my suggestion to the bankers is that, look, if you have a first charge and there is a second charge holder, please, and unless the amendment comes, because in the amendment, the committee has said that between the creditors, the contracts between them, first charge and second charge, must also be recognized. That is what they have mentioned. But till that time that clarification comes, there is a confusion. I agree with you. And that's the way we are going to deal with it in section.
Sir,
Sir,
if first charge holder
Mr.
relinquishes and second charge holder doesn't relinquish, in that case, what will be the position, sir?
See, that again there is a confusion because that's not going to happen. If that is happening, then it becomes again a problem, because if the first charge holder relinquishes it and second charge holder does not relinquish it, then will it be a part of the liquidation estate? That's the big question, because still there is a charge. So it's the subservient charge which is there. Of course, liquidators have not faced this issue so far, because second charge holder generally presume that they are inferior to the first charge holder, so they don't say. But somebody takes that stand, which you are saying is going to create a problem. There's no answer, sir, to this question.
Thank you, sir. Thank you.
Okay.
Sir, Ravichandran here. Sir, actually, I asked a question, this 53.
Okay.
And Mr. Yogesh Gupta seconded. Of course, credit to him also, not a problem. But, my only request is that, no, nothing actually. So my only request is that when they are amending this 53, can they not, amend this first charge, second charge disputes? Because some of the cases we face this problem.
It is under the consideration of the government. That much I can say, because it came into the committee. They said that inter se agreements between the creditors should also be recognized. This is known as inter se agreements. First charge. Okay. So for everyone, let's say Section 53 question was raised by Mr. Ravichandran, followed up by Mr. which
Credit to both. Yeah.
Credit to both. Yes.
Thank you.
Okay. I think, Shishi, I think there could be many more questions, but we have to respect the timings and all that. So maybe that any other questions which we can later on take it up.
Yeah.
And there are many forums we can.
I think it has been a wonderful question. Satwinder ji, you thought out this program with ICSI insolvency. Hats off to you. And all senior IPs are appearing here. I can see a lot of our friends who are there. Fantastic. I think you come to these kind of forums. I think this makes it more successful than us. You see, we are sharing knowledge and whatever we have.
we always look for the wisdom of this law from you, sir, also. But that's
absolutely, sir. Thank you so much for inviting me.
Right. Thank you.
So we can hand it over to the organizers. Anu,
Anu,
you can take it over.
Thank you so much, sir. Sir, thank you so much for your time, sir. Thank you, Ashish sir, and thank you, Satwinder sir, for your time and the efforts you make. Thank you.
Thank you. It was a pleasure.
Thank you, friends.
Thank you.